It's a big observation that has come to the fore by the Karnataka High Court. This is over child marriages. The High Court has refused the argument that a minor Muslim girl's marriage or attaining puberty will not contravene the Child Marriages Act. The High Court rejected this argument that under Muslim law, a girl aged 15 years could be married. The High Court has made it very, very clear that the POCSO Act, which protects children up until the age of 18 in this country, reigns supreme as far as marriage is concerned, and no personal law can override it. Ananya, my colleague, is getting us the very latest as far as this landmark judgment or observations of the Karnataka High Court, in fact, are concerned. And Ananya, this is definitely a big win as far as child rights are concerned.
Well, definitely the Karnataka High Court has now rejected the argument that a 16-year-old can be married under the Muslim law. Remember that the court was hearing a bail application filed by a particular person who had thought that he had married this particular girl who was a victim, but then the court has rejected this argument. And remember that this is happening not only for the first time, but we saw a recent judgment which was on a contrary terms, wherein the Punjab and Haryana High Court had twice, once in June this year and another time on September 30th this year, has actually passed judgments wherein it had allowed a 16-year-old Muslim girl to actually get married because it is allowed under the Sharia law, is what the Punjab and Haryana High Court had noted. However, the judgment that has been rendered by the Karnataka High Court is in fact contrary to the observations of Punjab and Haryana High Court, and it has clearly said that though it is permitted under the Sharia law, though it is permitted under the Child Marriages Act of the personal laws of Muslims, but then we have to understand that the child rights are also governed by special laws like the POCSO, that is the Prevention of Children from Sexual Assault. So this particular law overrides all these personal laws because it is, the POCSO Act is a special law, and that's the observation that was made by the Karnataka High Court. But what is very, very important at this point of time is that all of these observations, all of these debates are coming in because there is a vacuum in the law which can be filled by a uniform civil code when there would be in fact, same rights for all, same marriage age for all, or same age of, in fact, divorce, and same terms would be used for such personal laws. So that's the reason why there is always a push that is being given out for a uniform civil code, and that's where the debate of the UCC comes in. Though there are a lot of problems. Remember, when the petitions regarding the UCC had come up before the topmost court of the country, the central government had said that it's a very, very technical issue, and a lot of, in fact, personal laws have to be studied, and then a way has to be found out from all of this to give out equal rights to everybody, and there has to be an equilibrium that has to be maintained, and that's the reason why the Law Commission of India has to actually study this particular subject, and that's the reason why the central government is seeking more time in order to think about UCC.
Absolutely. So the timing of this observation from the Karnataka High Court comes at a time when we have at least one state that is again making a renewed push, which is Gujarat, for UCC. Now, Ananya, like you've been saying, that this is not the first time observations about child marriage and personal laws has come to the fore from a court of the country. It was recently, like you pointed out, that the Punjab and Haryana High Court also said that as per the personal law, a minor could be married at the age of 15 or at the age where they attain puberty. But that case then went to Supreme Court, if I'm not mistaken, and a notice has been issued to the centre as well to respond on that.
Well, definitely, Poonam, the NCPCR, the National Commission on Protection of Child Rights, had actually challenged this particular order of the Punjab and Haryana High Court, which was passed in June this year, which actually allowed a 16-year-old to get married under the Sharia law, which was now challenged by the NCPCR. Solicitor General Tushar Mehta recently appeared before the Supreme Court of India when the matter was being taken up, earlier this month. And he said that there should be a stay on this particular observation. However, the Supreme Court said that it would be examining it after all of the replies come in, and had issued notice. The matter is now listed for hearing before the topmost court of the country on November. Watch as to how the Supreme Court would proceed into this particular case, because remember that this is not just about child rights. This is not just about a uniform age of marriage or what, but then there has to be a mechanism, there has to be something or the other that has to be there which provides the equilibrium